So you're tangled up in a property dispute and you're wondering, what's the first move? It all kicks off with one crucial document called a plaint. Now think of it like this. You're basically telling your story to the court. In this explainer, we're going to break down exactly how you write that first, all-important chapter of your lawsuit.
You've got a disagreement over land. Maybe it's a family issue, maybe a sale that went sideways. The big question is, how do you take that personal conflict and turn it into a formal case that a court will actually listen to? Well, it all starts with knowing precisely where to go.
Before you can even begin telling your story, you've got to find the right stage. And in the legal world, especially with property, it really is all about location, location, location.
Finding the right court is actually simpler than you might think. Here's the golden rule. Your lawsuit has to be filed in the court that has power over the geographical area where the property physically is. For most land disputes, this means you're going to start at the most local level, which is usually called the junior division court for that district. Now, this brings us to a key legal term you'll hear a lot: jurisdiction. Don't let the word intimidate you. All it really means is the court's official territory. A court in one city can't make a ruling on a property dispute happening in a completely different city, right? So the most important takeaway here is you have to file your case where the land actually sits. That's it.
Okay, so you found the right courthouse. Now it's time to introduce the main characters in your legal drama. Because, every lawsuit has at least two sides to the story. On one side, you have the plaintiff. That's you, or whoever is bringing the complaint to the court. You're the one saying, hey, something's wrong here. And on the other side, that's the defendant. That's the person or party on the receiving end of the lawsuit. And this is absolutely crucial. You can't just sue some random person. Your plaint has to clearly explain why these specific people are in a dispute. A lot of the time, the conflict is happening precisely because of their relationship. They could be heirs fighting over an inheritance or co-owners of the same piece of land.
All right, we've got the court and we've got the characters. Now it's time to set the scene. And by that, I mean describing the property, the very heart of the conflict, with absolute pinpoint precision. You cannot be vague here. I really have to stress this. The court needs to know exactly what land we are talking about. Think about it. Any order the court eventually makes has to apply to a specific, identifiable piece of property. So you've got to include its location, its nature, like is it ancestral and still undivided, its type, agricultural or residential, and maybe most importantly, the exact plot numbers from the official records. Every single detail counts. We've set the stage, we've introduced everyone, and now we get to the core of the story, the plot twist. This is where you explain what went wrong. In legal terms, this is called the cause of action.
So what on earth is a cause of action? Well, think of it as the reason you're in court in the first place. It's the bundle of facts that, if you can prove them, shows that your legal rights have been violated. It's the why behind the whole lawsuit. Bottom line, this part of your plaint has to answer one fundamental question. Why are you here? You need to lay out the specific problem you're dealing with, crystal clear.
And these grievances, they can come in all shapes and sizes. For instance, maybe the property was sold right out from under you without your permission. Or maybe the land was never officially divided up between the legal heirs, and now it's just a total mess. Or perhaps some third party has gotten involved and is blocking you from using your own property. These are the kinds of problems that make up your cause of action.
Okay, you've told the court where this is all happening, who's involved, and what went wrong. The final chapter of your story is telling the judge how you want it all to end. What is the resolution you're actually asking for? This is known in the legal world as the relief or the prayer. And it's not a wish or a hope. It's a formal, direct request for a specific legal remedy. You have to tell the court exactly what you want it to do to fix this mess.
So what does this look like? Well, it could be a request for a declaration. That's an official statement from the court confirming that, yes, you are a co-owner. Or you might ask for a permanent injunction, which is a really powerful court order that stops someone from doing something specific, like selling the land. You're basically asking the court to step in and protect your rights. So when you take a step back and look at the whole thing, you see it, don't you? A plaint really is a story. It has a setting, the court's jurisdiction. It has its characters, the plaintiff and the defendant. It has a central conflict, your cause of action. And it has a proposed ending, your prayer for relief. So there you have it. You've carefully put your story down on paper and presented it to the court. But you got to remember, filing the plaint, that's just the beginning.
The real question now is, have you told a story that's compelling enough for the long and sometimes complicated legal journey that's waiting for you?